Hello everyone, welcome to Legal Darshan. In this video, we are going to discuss two cases which are relating to a similar issue. Okay, so basically the two cases are number one, Rojer Mathew versus South Indian Bank Limited. It is 2019-16 SCR1, and the second case is the case of Madras Bar Association versus Union of India and another 2022 SC 2020 volume 2 SCR 246. Okay, now both of these cases deals with the tribunal, appellate tribunals and other authorities qualification, experience and other conditions of service of member rules 2017 and 2020 respectively. Right now, basically this is based on how the appointments in the tribunals shall be happening, because the legislature is passing the Finance Act 2017 and is making certain provisions with respect to appointment of the officers, appointment of the chairpersons, appointment of members, etc. What are the qualification, experiences, etc. And the power is being vested by way of sections 184 in the hands of central government. Okay, so basically we will first do the case of Rojer Mathew, which is coming in 2019, and then we will go forward to the case of Supreme Court Bar Association versus Union of India. Now, Madras Bar Association versus Union of India, because Madras Bar Association case, it is a multi-fold litigation. So the first litigation happened before this case as well. It happened, one of the litigations happened in 2014, then Rojer Mathew comes up, and then we have Madras Bar Association 2020 case, which is also an extended litigation on a similar issue of the appointments of members in the tribunals. Okay, so now when we look at the case of Rojer Mathew, basically in the Rojer Mathew's case, the challenge pertained to Section 184 of the Finance Act. Mainly the challenge pertained to Section 184 of the Finance Act as well as Part 14 of the Finance Act. Okay, now basically what happens, the background of the case goes like the Finance Act 2017's reorganized tribunals by merging many of them and delegated the powers to frame rules regarding their functions, appointments, tenure, and qualifications to the central government. Now, the 2017 rules are passed in pursuance of Section 182, 183, 184 of the Finance Act, and the rules are named as Tribunal, Appellate Tribunal, and other authorities, in bracket, qualification, experience, and other conditions of service of members rules 2017. Now, these rules are also in challenge in the case of Rojer Mathew, contending that they violate judicial independence and the powers that are given to the union government, to the central government by way of Section 184. It can fall in the domain of excessive delegation as well. Okay, now the court herein is holding that the part which is in challenge before the court, it is not per se unconstitutional. So Section 184 per se is not unconstitutional, but the rules framed in exercise of Section 184 by the central government with respect to appointment, etc., for the members of these tribunals, these were struck down because they were violative of doctrine of separation of powers and they compromised tribunal judicial independence in the tribunals as well. Okay, because the 2017 rules, they gave excessive powers to the members of excessive powers to the executive in reference to the appointment or service conditions, tenures, qualification for the members to be appointed in these tribunals. Okay, now basically also the Madras Bar Association versus Union of India 2014 litigation is also the case in which the court is recommending central government to frame new rules in accordance with the principles being laid down in the earlier decisions as well. Now the court finds that the tribunal rules that are in challenge before the court, they are not they are giving excessive powers to the executive, and they are not in line with the constitutional mandate as well, because these rules, if analyzed, these rules are providing, it is a prima facie occurrence that executive interference is tampering in the judicial appointments as well, and which is violative of doctrine of separation of powers, as well as there is element of excessive delegation of powers to executive as well, right? So now basically what happens is that the criteria that was mentioned, the experience did not pertain to whether judicial experience is required or whether not required. So there was some sort of ambiguity in the criteria that was being let down by the central government by way of the rules of 2017 as well. So these rules were rendered unconstitutional by way of the case of Roger Mathew. Now one more question arises in Roger Mathew's case, which is whether the Finance Act being passed as a money bill is a legitimate exercise of passing a bill as a money bill under Article 110 or not. This particular question was referred to a larger bench because the court could not perceive the view that was taken by Justice K.S. Puttaswamy's judgment, five-bench judgment, and this case is also being decided by a five-judges bench judgment, and hence the case was forwarded for a larger reference by a seven-judge bench to be considered whether this falls under money bill or not, because the court could not hold with the view that was taken in the Aadhaar judgment, in the judgment of K.S. Puttaswamy versus Union of India. Now, what happened in this case is basically this case puts a check on the executive overreach in the tribunal administration as well. It is so far evident by way of this, what the finding of this case is. All right. And then another thing that is happening in this case, it is also raising pertaining concerns on the misuse of money bill route that the parliament of may take, and it also indicated that the Puttaswamy judgment, in which it was held that Puttaswamy judgment held that the Aadhaar Act can be determined as a money bill. It also raises a concern that it should also be re-examined, right? This is one thing that is held in this Roger Mathew's case. We have made reference to Madras Bar Association 2014. We had made reference to Justice K.S. Puttaswamy's case as well because of the money bill debate that this case is striking, right? Now, moving on to the next case, which is our Madras Bar Association, pardon me for pronouncing it as Supreme Court Bar Association, but it is a Madras Bar Association case. Okay, so now we come to, this is case number 64 in the list of AOR leading cases. And the Madras Bar Association case, I'm just coming to it. Yeah, the Madras Bar Association case, it is 2020 litigation, and it is also revolving around the executive interference in judicial appointments. Okay, just give me 1 second so that I can open the judgment herein. Yes. Okay. Now, pursuant to Roger Mathew, pursuant to what happens in Roger Mathew, these rules which were struck down, these are now reformed. Okay, the Union of India is forming new rules in the exercise of section 184 of the Finance Act. Okay, let's just open the cover page of the judgment and then we can proceed. Now, a three-judge bench is moving forward with the litigation in the case of Supreme Court Bar Association. Okay, now basically what happened in Roger Mathew was that Finance Act provisions were upheld, but the rules were struck down in the light of being excessive in the light of excessive delegation as well as violation of doctrine of separation of powers and unwarranted executive interference in the judicial appointments. Okay, but now what happens in the case of Madras Bar Association? This case builds on the earlier litigation in Madras Bar Association versus Union of India, as well as the Roger Mathews case, and the petition is again challenging Section 184, which empowers the central government to make rules for the appointment, service condition, tenure of tribunal members, and also the Roger Mathew, when it struck down tribunal rules of 2017. The new rules were formed in pursuance of Roger Mathew's judgment in 2020. This particular case, the case of Madras Bar Association, is challenging the tribunal rules now. Okay. Now, the issue before the court is whether the rules formulated in 2020 in pursuance of Section 184 of the Finance Act 2017, whether they violate the principle of judicial independence with respect to, deciding what is the tenure, what is the qualification, selection, appointment, reappointment criteria, who is the selection committee, etc., by the union government in this case. Okay, now the court herein, so the three judges bench herein, comprising of Justice Nageswar Rao, Justice Hemant Gupta, and Justice Ravindra Bhatt. Now they are looking at the 2020 rules, and they are holding that the search cum selection committee, which is there in the 2020 rules, it should comprise of Chief Justice of India, and they are recommending that there should be formation of a committee as well. Okay, now they are also recommending that there should be a committee formed, and they are looking at the judge at the tribunal rules, and they are saying that even now the rules that you are making, okay, even those rules, they are not complying with the earlier judicial mandate that has been passed by this court time and again. Now court is basically looking at the reappointment provision is applying a lot of executive influence. It is allowing a lot of executive interference and undermining impartiality. The courts herein are looking at the qualification criteria is vague and arbitrary. And when you look at selection committee in the light of the rules, they are dominated by the bureaucrats majorly. Now, court is saying that independence of judiciary is a part of basic structure doctrine, and the administrative control or the executive control over the executive of the over the tribunals, it cannot be absolute. Okay, so the court is reading down section 184, reading down section 184, not holding it unconstitutional, but reading down it to align it with the constitutional mandate of separation of power and prevention of excessive delegation. The court issues some directions saying that some directions with respect to tenure, that tenure should be minimum 5 years, no reappointment unless it is based on judicial recommendation, and selection committee, we were talking of earlier, selection committee should not be dominated by bureaucrats, but it should rather be predominantly adjudicated, predominantly be by people who are sitting in adjudication, who are sitting in judicial positions. Primarily it should be headed by the Chief Justice of India or persons nominated by him in that regard. Now, this judgment is crucial here to understand because it is advocating for a national tribunal commission to be formulated. Okay, and it is saying that a national tribunal commission should come in the picture so that it can oversee the administration with respect to tribunals. Okay, so there is a mention, we'll just come to it. Yeah, so the court herein is holding that the Union of India is directed to set up a national tribunal commission as suggested by this court already, and these tribunals, okay, so these national tribunal commission, it will ensure that judicial independence is achieved, because judicial independence of the tribunals can only be achieved when the tribunals are provided with necessary infrastructure and other facilities without having to lean on the shoulders of the executive. Now the court is also holding that this national tribunal commission, it should be dominated by judiciary rather than being dominated by tribunal wings, by bureaucrats or executive wings, right? And court is also holding out for search cum selection committee, and which was already provided in the rules, and it is saying that there is some merit in the submission of Attorney General that presence of secretary of the sponsoring or parent department in the search cum selection committee will be beneficial to the selection process, and thus it was also one of the issues that the court herein is determining, one of the principles that herein is reaffirming. Now court herein is saying that Government of India is duty bound to implement the earlier directions and also constitute the search cum selection committee, in which Chief Justice of India shall be the chairperson, along with the chairperson of the tribunal if he is a retired judge of the Supreme Court or a retired Chief Justice of a High Court, and two secretaries to the Government of India. In case the tribunal is headed by a chairperson who is not a judicial member, the search cum selection committee shall consist of Chief Justice of India or his nominee as chairperson, and a retired judge of Supreme Court or a retired Chief Justice of a High Court to be nominated by the Chief Justice of India and Secretary to the Government of India from Ministry of Law and Justice, and a Secretary of a department other than the parent or sponsoring department to be nominated by the Cabinet Secretary. As stated above, the Secretary of parent or sponsoring department shall serve as member secretary or convener without a vote. Okay. Now, basically, the court is deliberating herein on the rules finding out what is rightly held, extracting it and modifying it so as to allow maximum judicial intervention in appointment of the members in the tribunals. Now, there were other parameters, for example, rent allowance. Those parameters were also visited by the court. Now, this judgment is reinforcing judicial oversight in tribunal appointments, holding that independence of judiciary is maintained, as well as there is no excessive delegation to the Union of India, and the executive interference is minimized. So that principle of separation of power is also upheld. Now, this particular judgment is also highlighting one thing, that there is increasing judicial concern over the executive bypassing constitutional safeguards in the guise of tribunal reforms as well, right? So this is it, which was discussed in the two cases with respect to the appointment of tribunal members, Rojer Mathew, and on Rojer Mathew, we are building up Madras Bar Association case as well. I hope the discussion is useful for you. For more such videos, please stay tuned with Legal Darshan. We have completed almost more than 75 videos on the discussion for the AOR examination. Remaining videos will be uploaded in like a day or two for you. I hope these are useful for you. Please stay tuned with Legal Darshan. Have a great day.